Greg and Russ pony show. I'm not sure which one of us is the dog and which one's the pony. Usually starts with who's going to go first and which one of us will filibuster the other one. So this is going to be a unique thing. We're not doing individual presentations. We're going to go back and forth and try and make it more of a discussion this morning. That doesn't mean we're not going to filibuster. So for those of you who don't know, I was actually the first general manager of the Edwards Aquifer Authority, and I was basically the person who recommended to the board that the Day and McDaniel permit be denied. That resulted in some litigation and ultimately resulted in a Supreme Court decision in Edwards Aquifer Authority versus Day. A little bit of history about the permit itself. The Day and McDaniel Farm Ranch was very far south in Bexar County. They were very close to the bad water line. As a result, the well that they drilled essentially had been eaten up by the sulfur that was there, and so it became a free-flowing artesian well. Just pretty much flowed all the time. It flowed out of the well and into a drainage ditch, and from there it went into a soil and conservation built dam that formed a lake, which they used mostly for recreation. And then they would pump water out of that lake to irrigate most of the pasture land they had for their ranch. They did have 7 acres of land that they were able to pump the water directly from the well to irrigate that 7 acres. So when it all came through the contested case process, the SOA administrative law judge recommended that they get a permit not for the 750 acre feet that they had requested of 2 acre foot per acre for the 350 acres they had irrigated out of the lake, plus 50 acre feet more for that recreational pond. Instead, they got a permit for 14 acre feet. For some reason, they weren't happy with that, and they filed a lawsuit. The trial court ruled that the permit was correct and that the other constitutional claims that were being made by Day and McDaniel were not valid. They said that you don't get to make a takings claim because under the rule of capture, you don't have any claim to ownership of that groundwater. It's not a vested property right before you capture it. The act of capturing the water is when that property right vests. So that was appealed to the Fourth Court of Appeals, and the Fourth Court of Appeals held that they overruled the trial court. They said that the water in the lake was being put to a beneficial use, and therefore they should have gotten a permit for some portion of that. They said at least 150 acres. They didn't find evidence in the record of 300 acres. But they also denied all of their claims that were based on the Constitution. The Fourth Court then overruled the trial court, and that meant it was going to go to the Supreme Court. Both sides actually appealed to the Supreme Court because Day and McDaniel wanted to get their takings claim in, and EAA wanted to get the proper permit because they didn't think that they were entitled to the water that would flow into the lake. So the Supreme Court took up the case. It's one of I think, a fairly rare case in that they really went in depth, probably more in depth than they needed to answer the question, in laying out all of the ways groundwater conservation districts can regulate, the whole takings analysis, and ultimately reached the wrong conclusion. It's kind of, I say that laughingly because the truth is the Supreme Court doesn't make wrong decisions. They're the decider. Whatever they decide goes. So from that point forward, that vested property right in the groundwater prior to capture is the law. I want before I let Russ talk, I want to kind of go through just a real quick list of the decisions that were made and who won that decision. Edwards Aquifer Authority won on the following issues. The correct permit amount was the 14 acre feet because the water that flowed into the ditch, as soon as it crossed the banks of that ditch, it lost its character as groundwater and became state water. So the water that they pulled out of the lake was all essentially stolen from the state and not the property of Day and McDaniel. The regulation that allows some use of groundwater, the exempt uses of 25,000 gallons per day and the 14 acre foot permit, cannot represent a physical invasion of the property. So they said this isn't a physical invasion taking it all. The regulation is essential in the conservation and use of groundwater. Since 1904, the Supreme Court has been saying, legislature, you need to take care of this problem. We don't want the courts taking care of it. You need to have administrative law handle this rather than litigation. They then said SOA did not have authority to rule on constitutional issues, such as whether or not the EAA Act was constitutional. That's something that Dana McDaniel had argued. They should have been able to put on their takings case at the SOA level. They did not have a right for its contested case hearing to be before the full board instead of SOA. That was another argument they made. Day's open courts claim, which is a constitutional claim, and complained about the ex parte communications allowed by the Administrative Procedures Act between the ALJ and the agency staff were all dismissed. EAA won those issues. The court said the substantial evidence rule does not deprive Day of the right to present evidence of his takings claim. It said EA's issuance of a conditional drilling permit was not arbitrary or capricious. It said the state has a legitimate interest in discouraging suits against districts. Therefore, 36.066G about attorney's fees was rationally related to that legitimate state interest and therefore does not violate Day's equal protection rights. Day won on the following issues. The trial court should have considered Day's takings claims because there's a vested property right in groundwater prior to capture. That's the only issue they won, and that was the big one. So from here, I'm going to turn it over to Russ and talk about some more of the history of I guess, the EAA and how we got here.
Thanks, Greg. And, you know, we've done this. We've been on the podium together for, 20 years now. And I think it's helpful to kind of put this in perspective. First, I want to read you from a Baylor Law Review article published shortly after the decision. And interestingly, the author or professor starts the review with this sentence. In early 2012, a watershed Texas Supreme Court case, Edwards Aquifer Authority versus Day, turned Texas water law on its head. I'm here to argue that, in fact, it set it on its feet and correctly set the parameters within which regulation of groundwater by groundwater conservation districts should occur. So I thought that was kind of an interesting little observation. I also brought the Austin American-Statesman front page from Tuesday morning. I woke up to come down here for the conference, and the headline was, "Less groundwater, more demand." So I felt like that was a signal that this is an important topic and worthy of consideration. So just by way of background, at the time I practiced law in San Antonio. My principal client was the city of San Antonio's water system, SAWS, and as a consequence, as their principal lawyer, I was involved in all the battles that led to the creation of the Edwards Aquifer Authority. And I want to give you just kind of a brief summary of what took place to lead to the passage of the act. But I like to say, in terms of the speakers this morning, I was there at the creation, actually pre-creation and inception. Greg was an observer and an active participant shortly thereafter, so he took over at birth. So that's kind of a summary of of the history, and I want to set it in context, because I would like to say right up front that I'm not sure that a similar piece of legislation would survive challenge today if passed for a variety of reasons. But understand that the problem was that San Antonio relied exclusively on the Edwards Aquifer for its municipal water supply. And it did so with the assurance of the case law that said, in essence, the producer of groundwater was not liable to others for the impact and potential adverse effects of their pumping. And most importantly, in the Clayton Williams case, Fort Stockton held that, in essence, the groundwater producer was not liable for drying up a spring, because that's what Clayton Williams had done in connection with his agricultural operations to Comanche Springs. So that led, frankly, and keep in mind that the spring flow from Comal and San Marcos Springs in times of low rainfall provides up to 70% of the base flow of the Guadalupe River. That is the discharge point, if you will, for Comal and San Marcos Springs. So in essence, you have the classic situation of downstream dependence on spring flow and groundwater production dependence on those that use the aquifer. And to make it more complicated, there were really three distinct interest groups involved in the Edwards Aquifer. To the west of San Antonio, there was a tremendous amount of irrigated agriculture supported by production from the Edwards Aquifer. And those farmers used virtually as much water, perhaps more, than the entire municipal community in San Antonio. So I, back in the day, used to say the aquifer's total recharge, if you will, its input, was dedicated to roughly three equal parties: the farmers to the west, the San Antonio, New Braunfels, and San Marcos municipal use and industrial use, and then the springs. And oddly enough, each of those groups used about a third of the average annual recharge. So to make a long story short, GBRA, the manager of the Guadalupe River, went on a jihad in the 1980s to correct what they felt was a threat to their river system, filed a bunch of actions, including an action to declare the Edwards as an underground river, but most importantly, filed a lawsuit against the state of Texas, basically alleging that the state had failed to address the impact of production on the springs. And the reason it was filed under the Endangered Species Act is because, of course, there are endangered species that reside at Comal and San Marcos. So that case was tried to Judge Lucius Bunton in Midland. Judge Bunton never met a state problem that his federal court couldn't solve. He was what we would call an activist judge. Ruled for the plaintiff and ordered, in essence, the state of Texas to either create a solution to the problem or suffer the court's remedy, which would have been primarily focused on protecting the springs under the Endangered Species Act. And to put it further in context, the models showed that in order to protect spring flow at Comal and San Marcos Springs during a repeat of the drought of record, the total production from the Edwards Aquifer had to be less than 100,000 acre feet. And at the time, we estimated it to be substantially in excess of 400 to 450,000 acre feet. So that framed the issue for the Texas legislature in 1993, which led to the passage of the Edwards Aquifer Act. And I think it's safe to say that the act was controversial when passed. I think it's also important to note that the minute it became effective, and by the way, it was passed in '93 for voting rights reasons. The federal government blocked the implementation of the act after its passage. So it wasn't until '95 that the legislature had a chance to kind of fix that problem. As a consequence, the act didn't become effective until 1996. when it did, I'm sorry, in 1995, I guess. 96. Summer of 96, immediately the Medina County Underground Water Conservation District challenged the constitutionality of the act and filed a lawsuit. And to make a long story short, in that lawsuit, the court didn't decide whether the groundwater right was a vested property right subject to constitutional protection, but assumed that, and then, in essence, found that the facial challenge, the pre-implementation challenge, did not have merit because it was possible in the court's mind that the act could be implemented without trampling constitutionally protected rights.
Just a quick note. In that bar shop case, bar shop was alphabetically the first director listed of the directors being sued by the Medina County Underground Water Conservation District. I filed a friend of the court brief, and in that brief I made the argument that there can't be a taking of private property, that the act cannot cause a taking of private property because the rule of capture itself precluded that. And I, again, made the argument that right doesn't vest, that property interest does not vest as a property right until the water is actually captured, and I got that straight from the rule of capture. And we argued about that question for the next 20 years.
So to make a long story short, Greg summarized the process of deciding whether Day and McDaniel were entitled to a permit. I think an important point that needs to be recognized is that groundwater loses its character under the Supreme Court's decision as groundwater when it's put in a watercourse. It then becomes the property of the state and is no longer subject to the ownership of the landowner. So with that, Greg, that kind of sets the stage for the decision. You want to cover briefly the decision? Or?
Well, they decided, of course, that there is a vested property right in situ prior to capture, but not in any particular amount, which, again, doesn't make any sense to me because in order to have a vested right, it has to be measurable. They even say that in the opinion. There has to divest, you have to have a measurable, determinable amount. But then they go on to say we can't do that for groundwater because groundwater recharges and discharges. It comes out through springs. Lots of people are pumping it all. The rule of capture says everybody gets to pump as much as they want to unless there happens to be an administrative law overlay of a groundwater conservation district there to prevent that from happening. I think a couple of the important holdings, it's important to mention that first, of course, they said whether groundwater can be owned in place is an issue we've never decided. So all of those arguments I had with Russ for the years before that, I was right. They had never decided that question until this case. But we held long ago that oil and gas are owned in place, and we find no reason to treat groundwater differently. They then went on to talk about all the ways we have to treat groundwater differently than oil and gas, but that creates the problem of do we follow all oil and gas law when we're dealing with groundwater? And the answer to that's going to be in some cases yes, and in some cases no. The cases that have already been decided, generally the answer has been yes, we're going to treat it the same as we do oil and gas. In many areas, another part of the opinion, in many areas of the state, and certainly in the Edwards Aquifer, demand exceeds supply. Regulation is essential to its conservation and use. So while holding that the regulators can be held liable if their regulations go too far, they also said that regulation was absolutely essential. This is one of my favorite quotes. Groundwater is different from oil and gas. Aquifers are often recharged by rainfall, drainage, or other surface water. The amount of groundwater beneath the surface may increase as well as decrease. Any volume associated with the surface is constantly changing. Groundwater's many beneficial uses for drinking, agriculture, industry, and recreation often do not involve the sale of the water. Its value is realized not only in the personal consumption through crops, products, and diversion. Groundwater may be used entirely on the land from which it's pumped, or it may be transported for use or sale elsewhere. Consequently, regulation that affords an owner a fair share of subsurface water must take into account factors other than the surface area. So, the direct statement, we shouldn't be following correlative rights, so where the amount of groundwater you can pump correlates directly to the amount of surface acreage you own. A landowner could not be deprived of all beneficial use of the groundwater below his property merely because he did not use it during an historical period and because the supply is limited. So the court said every landowner is entitled to get access to their groundwater, but you have to be able to regulate it. And that regulation doesn't have to be based on the amount of land that they own. And it's vested, but not in any particular amount. That means we've had a huge number of questions that opened up, and a lot of them have yet to be decided. We have had several lawsuits that have occurred since then, of course, the most significant one being Bragg versus EAA. The Bragg pecan farms, they had two orchards. One was the Home Place Orchard in Medina County. The other was the DeHennis Orchard out near DeHennis. The DeHennis well wasn't drilled until after 1993. It was in that interim between when the act passed and when it took effect. A bill that was filed to change the dates to allow to cover those wells drilled during that period was killed on the House floor by a point of order. So the dates never moved. So everybody who drilled a well between 93 and 96 was in the same position as the Braggs in that they didn't have historic use that they could use to claim that EAA permit. So the DeHennis Orchard was denied. You cannot get a permit for that. Statute said that. On the Home Place Orchard, they got the exact same permit every other irrigator got. They got 2 acre-foot per acre for every acre of land that had pecan trees on it. The problem is, and they were able to prove this up in their trial court later, pecan trees need 6 acre-foot per acre, not 2. So their investment-backed expectations, their investment in their property as pecan orchards, required a minimum of 6 acre-foot per acre. Now the Braggs in their lawsuit tried to argue the amount of water we're not allowed to pump is the measure of the damages. And Saws is currently paying $5,000 an acre-foot for that water, so we want $5,000 an acre-foot for every acre-foot of water we cannot pump. The Fourth Court said that's not how you do the measure. It said the measurement there is based on the value of the property as a whole for its intended use based on your investment. So if you invested in pecan trees, you have a much better claim to that takings than someone who was growing corn or somebody that had a small business on that property and only needed a small amount of water. So while they flat out said you cannot deny someone access to their water, Bragg said the only way we're going to measure damages is based on your investment back to expectations. So the first question I have is, what are the damages for someone who's never drilled a well? Russ?
You know, I love it when he throws those hard balls at me, particularly when he aims it right at the head. But the bottom line, and this is really the fundamental question that's still, I think, unanswered, is what about those folks that haven't invested in producing groundwater? Are they protected? And do they have a claim if that right is eliminated? And I would also say that the Supreme Court, if they had to look at it again today, might be less dismissive of the correlative rights concept of ownership or use, given the potential that the only claims that will be recognized are those that are based upon some investment-backed expectation. And I get it. I understand the jurisprudence with regard to regulatory takings. But as a practical matter, it's an ironic result that those that are protected are those that have used the resource, not conserved it, and those that are not protected, arguably, certainly in Greg's mind, are denied the benefit of their ownership of that groundwater potentially if they're told that they cannot produce it. So I think it sets the stage for, and I want to kind of follow up on where we are and what it means. There's been very little jurisprudence since day on the takings issue. There have been some cases. Greg may cover one of them, but interestingly enough, in the Coyote Lake Ranch case decided by the Supreme Court, which I won't bore you with the details, but it was a battle between the city that owned the groundwater rights and wanted to produce that groundwater, and the surface owner that wanted to develop that property, and the city's well field would have interfered with that intent. And the Supreme Court basically, despite its dismissal of oil and gas laws relevant to groundwater management, determined that the accommodation doctrine in oil and gas, which basically says while the mineral owner is the dominant estate, the surface owner has the right to continue, and damage caused by the operations should be considered. So bottom line is the Supreme Court adopted an oil and gas principle that protected the surface owner from the actions of the groundwater owner and producer. And interestingly enough, so the law has been well established. That's true in oil and gas for decades, maybe a century. It was the first time, of course, that the Supreme Court had addressed that question. And interestingly enough, ascribed dominant estate character to the groundwater estate, just like oil and gas. And so one of the questions that I always have is, well, which of these dominant estates is more dominant? What if you have a oil and gas owner who wants to use groundwater, and you've got the groundwater ownership in presumably either an independent party or the landowner, which is also a dominant estate that would be adversely affected. So which of those dominant estates prevails? I throw that back to you.
That's a great question, and I have to tell you, one of the open questions that we're going to have to answer eventually is where we have set a limit on how much can be produced per acre, for example, and there's an oil and gas operation there, and that oil and gas lease says we get to produce as much water as we need to be able to explore for and capture this oil and gas, and they're using all of the available supply. What does that leave left over for the owner? And the oil and gas, by the way, is 100% exempt from regulation by the Groundwater Conservation District. The mining operations, obviously, if you have to dewater a mine, there's no way that the district can say you can't pump that much water out because that makes the mine inoperable. Oil and gas operations are exempt from district regulation, and especially, well, the law says it's in terms of drilling, getting a drilling permit, but I don't know of a single district that tries to regulate the operation of a well for oil and gas operations, other than there are a few districts out there that do try to regulate oil and gas operations if that water is being used for fracking as opposed to rig supply for a drilling rig. So that is one of the main open questions, is which is the more dominant estate. And it's probably going to be a long time before we get an answer to that particular question, because I don't see a lot of conflict there. I do want to point out, very important case, right after the Day case came out, a group of ranchers came in and applied for permits from EAA. This was, the deadline for filing an application was December 30th, 1996. They filed their applications in 2012. Those applications were obviously denied. The statute prohibited those permits from being granted. They sued, also in federal court, and the federal court judge ruled that there was no equal protection problem, there was no due process problem, and their takings claim was too late. They said there's a 10-year statute of limitations on filing a takings claim. GG Ranch is the name of the case. They appealed that to the Fifth Circuit Court of Appeals. The best opinion I have ever read out of the Fifth Circuit It's so good, I actually memorized it. For the reasons stated by the district court, we affirm. That's the entire opinion. So that's what saved the Edwards Aquifer Authority. Had that case gone forward, had there been potential takings claims from all the people who were going to come in and apply for permits, that would have represented thousands and thousands of landowners who did not qualify for a permit but owned that land and owned that groundwater, but now they're too late to make that claim. So that's why there's never going to be another EAA, because no one's going to make that mistake again. No one's going to wait 10 years to file that lawsuit.
Let me jump in and hit some of the big questions, because I think that's why we're here, really. So I asked this question rhetorically. Is the MAG number, the Managed Available Groundwater number, a limit on total permits issued? And I would suggest that the answer has to be no. The problem is, and by the way, the MAG for, if you will, the preservation of spring flow in the Edwards Aquifer is way lower than the total permit amount. I think total permits are how much? 600, 700,000 acre feet?
In the Edwards?
Yes.
I think it's 587 or something like that.
587. Yeah. Even though the statute had established a limit of 450.
450, right.
So you have to ask the question, what happens when you get to the MAG? What is your groundwater district to do when it's
when production equals the model available groundwater number? That's the problem.
And that is a huge problem. So what do you do, Greg?
I have no idea. You can either, before a day, I told my clients, you can say we're going to stop issuing permits. We're done. I think the Supreme Court's going to look very badly at that decision. They've said you can't tell a donor they can't have access to their groundwater. The other option is grant the new permit as it comes in, give everybody else a haircut in order to make room for the new permittee, but that opens the potential for them suing you for takings. So more than likely, and I think we agree on this point, the MAG is going to change. The DFC is going to change to allow more production to occur, and that's just going to continue time after time so that the districts can avoid these lawsuits.
So I want to throw out a couple of other things that are, of interest and unanswered. Districts that regulate by spacing only run the risk of having to say no to a potential landowner who would otherwise be able to produce groundwater because the spacing rules of the district prevent them from drilling a well within a certain distance of an existing well. I throw that out as, what do you do then, Greg?
Well, and the other problem with that is right now they're not required to get notice of the original permit for the original well, and they don't, I think, have standing to challenge the drilling of that well. So where the spacing regulations allow me to drill a well on my property that eventually tells Russ he's not allowed to drill a well on his property, that definitely could be very problematic for districts.
So the other area of concern, I think, are those districts that regulate by use without reference to land ownership. And this also has some relevance to water utilities, particularly non-municipal water utilities, who obviously typically don't own a tremendous amount of property, but produce large quantities of water from a small piece of land. So what do you do? I mean, honestly, with this question of what's the impact?
And of course we have those lawsuits coming, I think, shortly based on the Vista Ridge pumping, where now in that case Vista Ridge did buy a lot of water rights, but the impact of their pumping is going well beyond the properties where they purchased the water rights, in not only within that district but outside the district into other counties. My recommendation to those utilities is they need to go start buying up water rights. I think that if you own a utility while you might be able to make a legitimate claim for your historic use and the amount you have already invested in producing, when you start to grow beyond that, I strongly recommend you do so through the purchase of water rights from other people so that you're covered both ways.
So, the next phase, I think, of jurisprudence on regulation of groundwater in the context of takings is yet to come. Clearly the groundwater districts and their management seek to protect the groundwater resource through limits. So when those limits are reached, one of two things is going to happen. Either the limits are raised to accommodate new users, or some adjustment needs to be made between those historic users and the new user, and and that's going to be a challenge for every groundwater district out there in avoiding takings claims. And that leads to the other question, and I think you identified it in the list you sent me, which is the domestic and livestock exemption provided for in Chapter 36 sufficient to avoid constitutional takings claim?
And that may be true for anything larger than 10 acres, because you're allowed at least one well per 10 acres, I think. I don't know if you got 50,000 acres, if that means that you can get 5,000 wells. But certainly if you have more than 10 acres, you're entitled to a domestic and livestock well up to 25,000 gallons per day. I think that's a capacity limitations. I think you think that means they can get to 28 acre feet per year. I don't know that it means they can pump the full 28 acre feet per year, but certainly that would apply to those exempt use wells. For anybody less than 10 acres, they have to come get a permit like everybody else, and they're going to have to prove up their beneficial use, and I think they're going to have to prove up in some cases no unreasonable offsite impacts. And if I've got a 65 by 100 foot lot in my suburban neighborhood, there's no way I can produce water from that well that's not going to have dramatic impacts to neighboring properties. And if every one of those lots drills a well, the impact on the aquifer is going to be absolutely devastating, and the impact on all the other wells there is going to be devastating. So yeah, that is a very, very tough question.
So, the other thing I think that we need to consider is where do we go from here in terms of takings claims and regulation. I do think we're going to see litigation in the future as mags are reached or permit limits are reached.
And because these are constitutional questions, it requires litigation. I don't think the legislature can address them statutorily.
So, we're running out of time, and I want to leave you with the bottom line. Groundwater conservation districts are going to have to walk a very fine line between regulation, protection of the resource, and the property rights of the regulated community. And it's a challenge. It's a major challenge that we don't have really jurisprudence to help answer how best to navigate that narrow channel between those two interests.
I'll leave you with this bottom line. As the Supreme Court recognized in Day, the only way you can protect your property rights in groundwater is if there's a groundwater conservation district telling your neighbor what they can and cannot do. And as all of the groundwater district managers here and board members here have already heard, landowners will tell you, I do not want you telling me what I can do on my property, but you better do something about that SOB over there because he's just being unreasonable. So that's the line. That's where we have to. Now, we had the Vizino case filed where a neighboring landowner tried to sue the district for granting a permit that allowed drainage from his property, and unfortunately that's settled. The insurance company wrote a check for that, and so we don't have an answer to that question. I thought that case might help give us an answer there, but it would have resulted, had the Vizinos won that lawsuit, that would have resulted in a bizarre situation where I can't sue the person pumping the water because of the rule of capture, but I can sue the district that gave him a permit and get my damages from the district. That simply cannot be the final result. If that's the case, there's no reason to have groundwater conservation districts. And while you zealously represented your client's interests, I have to point out that the $4.5 million verdict the Braggs won, 80% of that was paid by your client. So had your client taken the opposite position in day, it might have saved him $4 million.
You know, he loves to criticize. It's just inherent, and I think it's also important to note that the Day case did settle as well. And what is interesting about that is that if you applied what I call the investment-backed expectation approach to a takings claim by Day, and you use the model of Bragg to measure damages, the irony is that by the time the Day case was decided, the value of the Day property had quadrupled, largely because of development in the area. So it was a challenge to make a damage claim on behalf of Day in the context of the measure of damages that the courts had outlined. Thankfully, it settled. I think it settled for a variety of reasons, not the least of which was that the court's decision. Pardon me?
Fatigue.
Fatigue. But the court had also indicated that, kind of in no uncertain terms, that Day had been damaged by the potential loss of the right to produce the groundwater. So interesting questions still remain. I think we set groundwater law on its feet. We didn't turn it on its head. And by the way, it was a routine topic on groundwater law seminars, this question of whether the right was vested. Now that we know that it's vested, we have a whole myriad of new questions that need to be answered.
It's kind of like hydrogeologic studies. The only conclusion I've ever read in a hydrogeologic study is that we have to have another study. Same thing with litigation. The only thing that they settled is we're going to have a lot more litigation on this. And I want to leave my favorite question from all of this. We're trying to push very hard. We've seen a lot of legislative policy pushing us toward aquifer storage and recovery. Is groundwater stored in an aquifer subject to the rule of capture?
Yes, sadly. But
because if it's not, then it represents a super vested property right.
Indeed. So we have a lot of questions unanswered. Sorry we couldn't answer them for you, and thanks.